Welcome to the course on medical law. This lecture will be about medical law and policy. The concepts covered in this lecture are components of healthcare, role of the government, constitutional provisions on healthcare, judiciary on healthcare, specific laws regulating healthcare, the schemes and various policies of the government. The keywords of this lecture are mixed model of healthcare, Pharmacy Council of India, Ayushman Bharat, National Health Mission. There is a direct interface between medical profession and law. That is why the law and policy in India becomes relevant for medical practitioners and the entire healthcare industry. India, being the most populous country, encounters various obstacles in achieving universal access to health services. India has demonstrated significant advancement in development trajectory through the implementation of various endeavors such as National Health Mission. The issue of affordability with regard to healthcare, the presence of various obstacles in maintaining consistent quality nationwide, and the attainment of equal health outcomes are matters of concern in India, particularly due to the high out-of-pocket expenses associated with private healthcare services. The various components of healthcare industry in India are the public sector, the private sector, either private or public, and the mixed models of both public and private. If you take the private sector in India, the majority of the healthcare providers in India belong to the private sector. They are duly registered in accordance with the provisions of the Clinical Establishment Act and are owned and operated by individuals or collective of individuals. The establishments like dispensaries, clinics, nursing homes, hospitals are capable of implementing many systems of medicine including allopathy, Ayurveda, homeopathy and Unani. So, the majority of the healthcare providers in India are belonging to private sector. It includes various hospitals, clinics and dispensaries which are around you, and they also belongs to different systems of medicine. The public sector is mainly under the jurisdiction of Ministry of Health and Family Welfare, Government of India. Apart from central institutions, there are also state institutions like hospitals and various clinics. These establishments includes dispensaries, clinics, nursing homes and hospitals that adhere to diverse medical systems. It encompasses the comprehensive network of health facilities across India comprising sub-centers, primary health centers, community health centers, rural hospitals, urban health centers, municipal hospitals and other government healthcare institutions. So, government, both the central and the state, is also a major service provider in the healthcare industry sector. So, especially in rural areas and villages and panchayats, the government plays a significant role in ensuring healthcare availability. Either private or public, the healthcare sector also encompasses several entities such as pharmaceutical firms, chemist shops, research organizations, medical colleges and other health related training and research facilities which can be either publicly or privately owned. Various entities including charitable institutions, religious organizations such as churches, NGOs and public sector bodies like Atomic Energy Corporation, Railways, Port Trust, Reserve Bank, Armed Forces also operates various healthcare services. So, they also have hospitals, clinics and other dispensaries in order to cater to the requirements of general public as well as their own employees. Mixed model. In a mixed model, the public and private sectors coexist side by side, much likely they do in India, whether the public sector is responsible for providing services while the private sector is responsible for providing care and insurance. The government has a significant role to play in making sure affordable healthcare is available for all its citizens. The central government establishes a comprehensive framework and is responsible for allocating financial resources to the state government for the purpose of implementing such programs. According to the constitutional provisions, the matters relating to public health, sanitation, dispensaries and hospitals are within the jurisdiction of state. So, in the constitution, the various matters which are to be dealt by the center and the state are allocated in various lists. So, entry 6 in the state list deals with the matters related to public health, sanitation, dispensary and hospitals which are within the jurisdiction of state, whereas population control, family planning are included in the concurrent list under entry 20A. So, that means with regard to population control and family planning, both the central government and the state government have equal roles. So, there are also various constitutional provisions which are directly relevant for healthcare industry in India. So, Article 21 of the Constitution, which speaks about the fundamental right with regard to right to life, is also covering the right to affordable healthcare. The Constitution ensures the fundamental right to life to all citizens and non-citizens in India. So, that means states have a responsibility to safeguard the lives of all individuals. The Supreme Court has held through various judgments that Article 21, which speaks about right to life, also includes right to health. Apart from Article 21, Article 39E, which is part of the directive principles of state policy, directs the state to secure the health of all workers. Apart from these two provisions, Article 41 is there, which pertains to provision of public aid in situations involving old age, disease and incapacity. So, apart from the positive right which is given in Article 21, there are also some specific stipulations in the directive principles of state policy which addresses the various aspects of affordable healthcare. So, under Article 21, the states have a responsibility to ensure the availability of healthcare to all human beings, and the directive principles of state policy requires the governments to strive towards achieving the objectives specified with regard to healthcare industry. So, apart from the various constitutional stipulations, the judiciary in India also has upheld the right to health of all citizens. In Bandhuwa Mukti Morcha versus Union of India, the Supreme Court in 1983 construed the right to health under Article 21, which guarantees life. So, in this case, which involved the various issues related to laborers working in the mines, the Supreme Court upheld that the right to health is guaranteed under Article 21 of the Constitution. In State of Punjab and others versus Mohinder Singh, the Supreme Court again stated that the right to health is fundamental to right to life and the government must provide healthcare services. So, through these decisions, the Supreme Court have already upheld that the state has a responsibility towards the citizens to ensure that they have availability of affordable healthcare. Supreme Court has further upheld the state's health service responsibilities in State of Punjab and others versus Ram Lubhia Baga case. So, all these cases denotes that the state governments have responsibility towards the citizens to ensure that their right to health is adequately protected. There are also specific laws in India with regard to healthcare industry. The Government of India has set forward the object of achieving universal health coverage, recognizing that healthcare is a crucial element of social welfare and progress. The government has enacted a range of legislations, statutes and schemes with the aim of fostering a state of well-being among the population. There are various schemes and legislations brought out by the central government and the state government. We dealing with various aspects of medical profession and education, nursing profession, pharmacists, pharmacy education, mental health, drug standards, advertisements pertaining to drugs and medicines, and prevention of spread of infectious or contagious diseases, and also prevention of adulteration of foods and drugs. In this lecture, we will be having an overview of the various legislations and policies of the government in India. Let us start with the Clinical Establishments Registration and Regulation Act of 2010. This is a legislation brought out by the Parliament which aims to develop a system for registration and regulation of clinical establishments across the country. So, this legislation primarily aims at establishing a set of minimum criteria for the facilities and services offered by these establishments. So, all the clinical establishments have to register under the Clinical Establishments Registration and Regulation Act of 2010 before they start functioning in India. The Act is inclusive of all categories of clinical establishments like therapeutic and diagnostic types operating within public and private sectors. This also includes establishments affiliated with all recognized systems of medicine as well as single doctor clinics. The sole exemption under this provision is for clinical establishments operated by armed forces. So, that means apart from the clinical establishments operated by armed forces, all the clinical establishments intending to operate in India, including the therapeutic diagnostic types, have to register under this legislation. This is not restricted to any particular type of system of medicine, but it covers all the different systems of medicine which are recognized in India. The Drugs and Cosmetics Act 1940 is another significant legislation with regard to healthcare industry. This legislation enacted by the Parliament governs the importation, production and dissemination of pharmaceutical substances within the country. The main objective of this legislation is to guarantee the safety, efficacy and adhere to quality standards of pharmaceuticals and cosmetics being marketed in India. So, all the pharmaceutical and cosmetic products which are intended to be marketed in India have to be registered under the Drugs and Cosmetics Act 1940. So, the Drugs and Cosmetics Act 1940 provides the stringent regulations with regard to ensuring the safety, efficacy and quality standards for pharmaceutical and cosmetic products in India. The primary goals of the Drugs and Cosmetics Act are the prevention of production of counterfeit and inferior pharmaceutical products, the importation of pharmaceutical substances into India and the regulatory measures for that purpose, the production and distribution of Ayurvedic, Siddha and Unani medications as necessary to implement regulatory measures. So, the Drugs and Cosmetics Act deals with various aspects related to marketing of drugs and cosmetics in India. It has measures to prevent the production of counterfeit drugs and pharmaceuticals and also ensure the adequate quality of pharmaceutical products. The Pharmacy Act of 1948 is another significant legislation which was established by the Parliament of India for the purpose of governing and overseeing the occupation and implementation of pharmacy in India. The handling, formulation, dispensing and storage of medicines which requires comprehensive and specialized understanding, expertise and training is dealt under the Pharmacy Act of 1948. The Pharmacy Council of India is a statutory body established under the Pharmacy Act of 1948. The primary goal of the Pharmacy Council is to establish educational standards that must be met in order to qualify as a pharmacist. This involves development of educational regulations that outline the specific requirement of institutions in order to obtain the approval of PCI. Recently, the Pharmacy Amendment Bill 2023 has been introduced in the Parliament, which is now under consideration. Biomedical waste management is another important area of concern with regard to healthcare industry. The management of biomedical waste holds significant importance in safeguarding the well-being of healthcare of the general population. The inadequate management of biomedical waste has the potential to facilitate transmission of infectious diseases and pollute the surrounding environment, and it also poses a risk of hazardous substance exposure to anyone involved in the treatment. The Biomedical Waste Management Rules of 2016 facilitate the process of disposal of waste. The Government of India introduced the Biomedical Waste Management and Handling Rules initially in 1998, which was subsequently modified in 2016. The primary objective of this revision was to enhance the process of collection, segregation, treatment and disposal of biomedical waste generated by hospitals and laboratories. Biomedical wastes are mainly categorized into four distinct color categories. The yellow category includes human anatomical waste, animal anatomical waste, solid waste, expired or discarded waste, chemical waste, etc. The red category covers recyclable contaminated trash, namely waste derived from disposable products such as tubing, bottles, intravenous tubes, sets, urine bags, syringes, gloves, etc. The white encompasses many types of waste, sharps, specifically those composed of metals that have been used, contaminated or discarded. The blue covers glass, metallic, body implants that are broken, infected or abandoned. The Mental Healthcare Act of 2017 is a legislative measure that aims to ensure the provision of mental health care and related services to individuals suffering from mental illness. Its objective is to safeguard, advance and ensure the rights of individuals in the context of mental health care and services. This legislation guarantees the individuals with mental illness the entitlement to lead a normal life characterized by dignity, free from discrimination or harassment. It grants the patients the entitlement to avail themselves various facilities like rehabilitation treatments within hospital settings as well as community, home and sheltered and supported lodging. The legislation also governs the investigation pertaining to individuals with mental illness and the utilization of neurosurgical interventions. The legislation is relatively vague on the provisions of community care. The Medical Termination of Pregnancy Act 1971 is another significant legislation. The enactment of this legislation was prompted by advancement in the realm of medical science like development of safer abortion procedures. This legislation was recently amended in 2021 with the aim to enhance availability of safe and lawful abortion services for therapeutic, eugenic, humanitarian and other social reasons. According to this 2021 amendment, a married woman has the option to terminate pregnancy within a time frame of 20 weeks in situations where contraceptive technique or technology has proven ineffective. This provision enables unmarried women to exercise their right to terminate pregnancy for the aforementioned purpose. The disclosure of identity and personal details of woman who has undergone the termination is prohibited unless authorized by a prevailing legislation. The implementation of the new legislation will make a significant contribution towards the reduction of preventable maternal death so as to aid the achievement of the SDG. The amendment of MTP Act 1971 is also aimed at enhancing the woman's empowerment through the provision of comprehensive abortion care to ensure universal access to reproductive health services. Apart from all these specific legislations with regard to healthcare industry, the Indian Penal Code 1860 is also applicable to various legal matters that are happening in the healthcare industry. The healthcare practitioners may face legal consequences under various provisions of the Indian Penal Code. Section 269 of Indian Penal Code pertains to acts of negligence that have potential to facilitate the transmission of infectious diseases. Section 270 pertains to activities that possesses malignant nature and have potential to facilitate transmission of infections or diseases. Section 304A deals with offences of causing death by negligence. Section 338 deals with offence of causing grievous injury through an act that poses risk to life or personal safety of others. So, apart from the specific legislations, the healthcare practitioners also has to keep in mind the various provisions in the Indian Penal Code that will be applicable to scenarios involving negligence or intentional activities from their side which causes any healthcare issues to the patients. Apart from the legislations, government has also came out with various schemes and policies with regard to healthcare sector. The National Health Policy of 2017 was introduced to replace the previous one which was initiated in 2002. The National Health Policy was intended to undertake the aim of enhancing overall healthcare infrastructure inside the country. The project encompasses all facets of healthcare industry, including illness prevention, promotion of good health through cross-sectorial efforts, investment in healthcare, enhancement of human resources, technological breakthrough and other related areas. The government health insurance schemes refer to programs implemented by the government to provide insurance coverage to individuals in India. These schemes ensure the citizens have adequate access in affordable and comprehensive manner with regard to healthcare services. These systems, which are either centrally or state sponsored, aim to offer health coverage at a very reasonable cost. Ayushman Bharat program, also referred to as Pradhan Mantri Jan Arogya Yojana, is a government initiative in India that aims to provide universal health coverage to all citizens. The program intends to cover medical interventions including knee replacement, prostate cancer treatment, double valve replacement, skull surgery with the aim of benefiting over 500 million citizens in India. The policy provides coverage for expenses incurred over a period of 15 days following hospitalization. The dataset consists of total of 1393 medical treatments. The Aam Aadmi Beam Yojana is another program of Government of India intended to address the healthcare requirements of low income bracket. It offers insurance protection to either the primary breadwinner or the head of the household. The beneficiary or the family member who is eligible to receive can get up to rupees 75,000 in the event of experiencing loss of an eye or limbs. The beneficiaries are provided under the following circumstances: mortalities resulting from natural causes or unforeseen incidents, as well as enduring or partial incapacitation. Universal Health Insurance Scheme is a comprehensive healthcare program that aims to provide coverage to all individuals regardless of their socioeconomic status or pre-existing medical conditions. This program was executed with the intention of providing healthcare protection to most economically disadvantaged households in the nation. The policy has a maximum coverage of rupees 30,000 in the event of family members' hospitalization. For individuals who are employed and earning income The remuneration is set as rupees 50 per day with maximum duration of 15 days. The National Health Mission was initiated by the government in 2013. The primary programmatic elements covers health system strengthening in both rural and urban regions, focusing on reproductive, maternal, neonatal, child and adolescent health, as well as communicable and non-communicable diseases. The NHM also aims to attain comprehensive accessibility to fair, cost-effective and high-quality healthcare services. It also offers assistance to states and union territories in establishing new facilities and improving the existing ones. It also offers assistance with regard to many complementary services pertaining to maternity health, child health, adolescent health, family planning, etc. Apart from all these, there are various other major initiatives supported by Government of India which can be seen here. To conclude, the healthcare policies are various rules and guidelines which are issued by the government to govern various healthcare services. The access, quality, cost management and public health are all significant factors that contribute to the importance of healthcare policy and law. The policy development is mostly led by governments who engage the various stakeholders in the healthcare industry like healthcare professionals, organizations, patient groups, insurance firms and academia. So, apart from the law which includes various statutes, rules and regulations enacted by the central and the state government, there are also different policies and schemes that cover various aspects of healthcare industry in India. The references of this lecture can be seen here. Thank you very much for listening to this lecture. I hope you are enjoying the course.